Welcome to Legal Talk, a conversation about governance issues that New York's co-op and condo boards are tackling right now. I'm Bill Morris with Habitat, the New York City magazine for co-op and condo board directors. And my guest today is Ken Jacobs, a partner at the law firm of Smith, Buss, and Jacobs. And Ken, there are some issues that are more controversial than others in co-ops. And right now, smoking is a big one. Not only cigarettes, but with marijuana coming on the scene. And that's going to be an issue when co-op boards want to ban smoking in their buildings. I guess the proprietary lease is the key document here. Tell us how a board can go about getting that lease amended to get through a controversial issue like a smoking ban.
Okay, sure. First of all, I'm glad you pointed out that the proprietary lease has to be amended because some boards have tried to impose this by regulation, and those have been struck down by the courts. What we're talking about when you say smoking ban is prohibiting smoking within apartments as well as in the common areas. In New York City right now, you're generally barred from smoking in common areas, but smoking is permitted within individual apartments. So what a lot of boards find is that when people complain about smoking, they have to confront going through the nuisance, proving it's a nuisance, testing whether or not there's the degree to which the nicotine is affecting the other apartment, maybe sealing apartments. They have to go through a lot of steps, and some boards are saying we just don't want to have to go through that. We don't want people to have to testify in court. We want to avoid this problem. So we're going to ban smoking within apartments so we don't have to ask how bad is it, how much is it really a nuisance?
Now, when you say ban it, what are they, by amending the House rules, or how would they?
No, that's my point. The way to do this is to amend the proprietary lease. The proprietary lease is considered a contract under New York law, and therefore the parties to the contract, which are the shareholders, can amend the proprietary lease. Usually, the lease requires a certain percentage, like 67%. Or 75% of the shareholders to amend it. And that's all the shareholders, not just the shareholders who are present in person. So in order to actually accomplish the amendment legally, the board has to create the proposed amendment, put it in a notice of meeting to the shareholders, call the meeting, and have the shareholders vote. But in reality, that's the legal way of handling it, but not the practical way of handling it, because people are inevitably going to have, not just about smoking, but any controversial issue, flip tax, marijuana, they're going to have questions about it and they're going to have concerns. So what I would suggest is the board determine whether they have a chance of getting this kind of support from the shareholders first, either discussions with other shareholders, a straw poll, and then when the board proposes the amendment, I suggest calling a meeting, calling a town hall or a Zoom meeting, and basically be there and have the lawyer there to answer the questions that shareholders are going to have. Take smoking. The first question they're going to ask is it legal to ban smoking in apartments? After all, it's a legal activity, and how can you interfere with what I do in my own apartment? And the board would answer something like, smoking is recognized as a legal nuisance by a number of courts as a matter of law. And because the proprietary lease is a contract, we have the shareholders have the ability to set the terms of that contract, and that would include what activities go on within your apartment.
Let me interrupt you here, Ken. You mentioned a straw poll. How does that work? Is that just an informal vote? The board sort of sounds out the residents of the building to figure out which way the wind is blowing, how they feel about this possible change?
Exactly.
How does a board do that?
The board might send around, if the board has emails or a newsletter, the board might send around something saying that we're contemplating banning smoking in the building, and we're soliciting some informal shareholder opinion about the concept. And please send in your email to management, to the board email, whatever. And it's just solicit responses that way.
So once the board has determined that there is a chance that this could go through, then they move on to the town hall meeting, and then from there, what, a vote of the...
Then after that, they would draft the proposed amendment, and they would circulate it to the shareholders. Okay, and they could do that in the context of, we're going to have a special meeting of shareholders to vote to amend the proprietary lease in 30 days, 45 days. And then in between sending out the amendment and having the meeting, that's when they have the town hall meeting, or they send around frequently asked questions to answer questions that they expect shareholders to have. And they basically become prepared with medical support, although for smoking, there's a huge amount of medical support, and legal support, so that shareholders aren't worried that they're doing something that violates the law. And eventually you have the meeting. Now, at the meeting, you need 2/3 at least of all the shareholders in the building in order to amend the proprietary lease. So you may not get that at the initial meeting. The board has the legal right to adjourn and reconvene the meeting. And what I mean by that is the majority of the shareholders present can vote to adjourn the meeting for another 30 days, for example, and reconvene the meeting. And the board can take that period to gather additional proxies from shareholders in order to get to that threshold. I've had boards adjourn and reconvene meetings for 6 months in order to pass a controversial amendment.
Well, now let's say that they finally get enough support. They pass it with a supermajority that's required, whether it's 2/3, 3/4, 4/5, whatever. It becomes a new part of the contract.
Right.
Fine and dandy. You can't smoke in your apartment, but of course somebody's going to smoke in their apartment, which brings us to the question of enforcement. Are enforcement measures baked into that change to the proprietary lease, or is that something else?
Yes. One thing about the amendment is you could bake in how it's going to be enforced, whether it's by fine or actual injunctive relief. In other words, going to court and getting an order from the court barring you from stopping smoking. Sometimes some boards have modified the amendment to allow a grandfathering period, recognizing that smoking is highly addictive. They say it's going to be enforced in 6 months. So you have 6 months to change your behavior or sell your apartment. Some boards have discussed whether or not to allow it on balconies. One of the inevitable questions you mentioned at the beginning is marijuana. How are they going to deal with marijuana? Are they going to treat that the same as cigarette smoke? Because apparently marijuana does not have the smoke of marijuana does not have the same damaging effects as cigarette smoke, and people tend not to smoke it as often as they smoke cigarettes. But nevertheless, a lot of people find the odor to be objectionable. And most of the boards which have passed a non-smoking amendment have also barred smoking marijuana within the apartments in order to avoid that problem.
So to wrap up, what's the lesson for a board that's trying to make a change, a controversial change? Doesn't just not confined only to smoking. We've been using that as a sort of a textbook example.
Right.
But to wrap up, what is your advice to boards if they get ready to do something that's going to be controversial?
Education and patience. The board can't just assume that everybody's going to go along with them. The board has to give people a chance to express their concerns and somehow respond to them between the date that they actually send out the proposal and the date of the vote. And be patient. It may not work the first year, but you could try it the next year or try it in 6 months. Something like a flip tax, for example, the first reaction people are going to have is, it's going to cost me money. It's going to hit marketability of my apartment. It's terrible. So the board has to explain and bring in evidence that no, it doesn't hurt marketability. By the way, same thing with smoking. Some people say, oh my gosh, people aren't going to want to move in if they can't smoke. But actually, it turns out exactly the opposite usually.
Fewer and fewer smokers, right?
Fewer and fewer smokers, and it's more popular. Yes.
Okay, so education and patience are the two bywords from the lesson
Yes.
today. Okay, well,
Yes.
Ken Jacobs, thank you so much. This is a valuable lesson for any co-op board that's trying to do something that may not be popular at first, but might become popular later. Thanks, Ken.
Oh, thanks, Bill.